It's a case between Lenovo and InterDigital. Here in the specific proceedings, it was Lenovo on the claimant's side and InterDigital was the defendant. This was a judgment that was delivered in March this year. And it is, of course, part of a much larger dispute between these two parties. Here, just some very basic facts, some very basic background to understand a little bit the context of this decision. So the dispute between InterDigital and Lenovo goes back to 2019. So that was the time when InterDigital filed the first lawsuit in the UK. And in the course of these proceedings, apart from all the topics that are, of course, also the technical merits of the patents that have been examined by the court had also the task to set up the terms for a global license, front license to InterDigital's SEP portfolio. And when I mean SEP portfolio here, we're talking about all 2G to 5G patents that InterDigital holds. Again, this is important because this is an element which the court discussed in the decision here and had some different views on the scope of the license. So what the court did there in the first proceedings was to make, at the end of the day, a front determination. It set the terms of a license agreement covering, again, only patents that are relevant for 2G to 5G. And also determined that this license agreement should run until the end of 2023. So that the determination was made in March 2023, and the agreement should basically cover the time until the end of that year, which is about 9 months. The court basically in this decision covered the past. So the license should cover past uses as well, starting with the year 2007. So the first license that the court determined here, the UK court determined, was a license that really looked into the past and past sales and had also a limited period of applicability going forward. What the court did then after that decision was delivered was also to deliver a ruling on interest. So it asked Lenovo to pay interest for the past to InterDigital, which was also a significant amount, and then also gave the parties permission to appeal this decision. Now, after that, of course, there was still a question open: what should happen after January 1st, 2024, because the agreement which the court determined in March 2023 would cover only the time until the end of the year. So what would happen after January 1st, 2024 was totally unclear. And this led, on the one hand, InterDigital to file a lawsuit in Munich asking for also an injunction against Lenovo. Lenovo, on the other hand, decided to go to the UK court again and ask the court to set the terms for a global license, which would start in January 1st, 2024. And here, the difference compared to the license that had been set before was that the determination was sought also covering patents that are not only relevant to 2G to 5G, but also eventually patents that are relevant to 6G, or standard essential patents that are relevant to other standards, which InterDigital holds, and even a license that would cover non-SEPs, the implementation patents. So this was the subject matter of these proceedings in the UK. And one of the things that InterDigital did here was to contest the jurisdiction of the court to make such a broad determination of front terms and conditions, especially to set a license with such a broad scope. And with the decision we are discussing today, the court replied to the fact that InterDigital contested its jurisdictions and confirmed its jurisdiction. It said that it has the authority basically to do this type of determination. We're going to see in a moment on which grounds the court based its decision. What happened afterwards was equally interesting. The Munich court 1 month later, in May 2024, granted an injunction against Lenovo in Germany. So these proceedings were very fast, as is usually the case, and InterDigital managed to get an injunction. And not only that, in the UK, in July 2024, so a couple of months later, the Court of Appeal delivered its ruling concerning the license agreement that was initially set by the court, which would cover the time until the end of December 2023. And there, the court increased the royalty amount that was payable to InterDigital under this license. It's added an amount of approximately, if I'm not mistaken, around 50 million. So it reached in total an amount of around 180 million that Lenovo should pay to InterDigital, which came around or something more than 200 million if you would also count the interest that is due to pay, that Lenovo is due to pay to InterDigital. So that was the status of these proceedings, which were running in parallel in covering different aspects. Whether this is going to move on is a bit questionable, at least as far as we understand. Lenovo and InterDigital seem to have reached settlement in the meantime. So it's not clear whether these proceedings are going to move on, especially whether this front determination for the license that would go and start after the January 1st, 2024 will take place. Now, if we look at the decision of the court here, there were two different type of claims that Lenovo raised in these proceedings. It asked the court to make declarations on invalidity, non-essentiality, and non-infringement of 2 UK patents. So this is, let's say, the more technical side of things, of the claims. What is in our focus is the other claim, which was a claim for a declaration that InterDigital is required to enter into a global license on the court-determined terms, which license would cover what the court called here cellular SEPs. So these are patents that have been declared to EWHC for 2G to 5G, and these are also the patents that were the subject matter of the first license which the court set. But beyond that, also a license that would cover other SEPs, and this included, for example, SEPs declared to EWHC for 6G, or SEPs declared to other SDOs regarding other standards, for example, a Wi-Fi or the EWHC standard. And the license should also cover non-SEPs, meaning implementation patents that InterDigital holds. So at the end of the day, this claim was very comprehensive. It sought the court to determine the front terms for a license that would cover basically the entire portfolio of InterDigital, irrespective of whether SEPs or not, and then also declare that InterDigital is required to enter into this type of agreement with Lenovo. Now here, as we said already, InterDigital contested the jurisdiction of the English court to do that, and that was the question that the court needed to answer here. So the basic question was, do the English courts have jurisdiction to set terms for a license that would extend beyond the cellular SEPs? This was the question because the court said, if we're looking only at the cellular SEPs, meaning the 2G to 5G patents, then it's common ground that jurisdiction is given. So this was not really a question that was posed here. The court referred, of course, to the previous decision that it had delivered and it had set terms for such a license, but also to other decisions where the High Court has done the same, for example, the Optis Apple case in the UK. Of course, whether the court had jurisdiction to go and set the terms for a license going beyond that was not common ground. This was what the court examined here. The court applied a standard which comes from UK case law. The decision is a case between AK Investment and Kyrgyz Mobile, and it basically has three conditions that need to be met here in order for a UK court to assume jurisdiction. There was particularly one condition, the first one, which is displayed here on the slide, that the court really focused on, and this is whether there is a serious issue to be tried on the merits, which would consist of a substantial question of fact or law or both, or in other words, if there is a real prospect that the claim would succeed. So this is the first condition. And the other two are, let's say, a more technical condition of whether the claim falls within one of the gateways that have been laid down in this procedural rules of that apply in the UK, and whether England is clearly or distinctly the appropriate forum for the trial. So these conditions, the two last ones, 2 and 3, were not an issue for the court. It focused basically on the first one. So whether this claim that Lenovo has raised here, which would basically require the court to make to set the terms of a license that would cover the entire portfolio of InterDigital, whether this claim would have a prospect of succeeding. And the answer of the court was yes. So this, what we can call the front claim, would have a realistic prospect of success in the eyes of the court. Now here, of course, the question is, how did the court come to this conclusion? And the court basically said, at the stage where we are now, so of course, this is not the final decision of the court, it cannot be ruled out that InterDigital could be required to offer a license to its entire portfolio. So this is something that the court at least could not exclude, so that it is a possibility that the court would find that this is the case, that there is an obligation to offer such a broad license. Where did the court base its decision, or base this this finding or this opinion? I mean, one obvious thing to look at here would be the front undertaking. Here we had particularly the EWHC front undertaking, which is subject to French law, and to examine whether French law would eventually establish such an obligation to offer and to grant such a very broad license, not covering only SEPs but also non-SEPs, for example. There was a bit of confusion here of whether Lenovo had made its case based on French law or had brought respective arguments. The court was a bit puzzled, but at the end of the day, the court said that it's difficult to see that French law would give rise to such an obligation. So this was not a basis where the court could that the court could use in order to reach this conclusion. However, the court said offering a license that would cover only the cellular SEPs could be discriminatory. And here the court clarified that discriminatory is not the same, has not the same meaning as it would have under French law, or as it would have with regard to the EWHC front undertaking, but it's a discrimination rather in the ordinary English sense, which means that you offer one thing to someone and a different thing to others. And what would be this thing that InterDigital would offer to others and not to Lenovo could be discriminatory? This could be a license, for example, that covers also patents beyond the cellular SEPs. And the court said here, if you would have a practice, a licensing practice on the side of InterDigital, which is basically going out and signs agreements, including patents other than cellular SEPs, then denying Lenovo to such a license could be discriminatory. So the court left this this open here, and so that this is something that you could eventually argue if there is a licensing practice that InterDigital follows, and it consists in doing exactly the opposite, not limiting the license agreement to the cellular SCPs, but also including other patents and non-SCPs. And there was one example which Lenovo had produced here, which was a license agreement between InterDigital and Xiaomi, which apparently covered 3G to 5G, but also Wi-Fi standard SCPs and also HEVC SCPs. So here the question was, are there similar licenses with other implementers? Because if this is the case, then this discrimination element could become stronger, and also something you could plead and be successful in the proceedings. Now, InterDigital tried to argue against that, and one major argument was to say that you have here already the same court with the decision that was delivered in March 2023, with the first FRAND determination that the court made, confirming that if you offer a license which covers only cellular SCPs, then you are FRAND, then you are safe. So here, basically, InterDigital's argument was to say, even if you would think otherwise, in any case, if I would offer a license that would cover only cellular SCPs, I would be FRAND. So it doesn't really make any sense to move on and make this whole determination of a license with a broader scope, because I could always have as a fallback a license that covers only the cellular SCPs. The same court, has already said that this license is FRAND. Now, the court was not convinced by this argument. It said the fact that we did that, and that the earlier determination of the FRAND license covered only cellular SCPs and was considered to be FRAND, does not necessarily mean that the same license would be FRAND now. And the court said basically two things. One could be that you get new facts. For example, comparable agreements signed by InterDigital with other licensees, new agreements that go beyond cellular SCPs. And the court also mentioned here that it's highly likely that you would ask and require InterDigital to disclose such agreements if they exist in the proceedings. So you could have new agreements changing the view of the court in this respect. But you could also look at the agreements that the court had looked at in the first FRAND determination and view these agreements with different eyes. So from a different angle, basically, if the parties would plead their cases based on a different premise. And what would be the result of that? So the court said, well, if you had a good proportion of InterDigital's comparables that covers patents going beyond the cellular SCPs, then basically Lenovo's case could be runnable. Then it would have prospects of success, that not offering such a license, such a broad license to Lenovo, could be discriminatory. On the other hand, if this was not the case and there was no such licensing practice on the side of InterDigital, then the court did not see any harm, because InterDigital could strike out the claim of Lenovo if the conclusion would be that Lenovo just cherry-picked some licenses, as for example the ones with Xiaomi, to make its case, but this was not something that corresponded to a broader or more common practice on the side of InterDigital. So this was one argument which InterDigital tried to bring here with not much success. The second one was basically to say that it doesn't make sense to go and take the time and effort to make this FRAND determination of a broader license. This determination would have no utility, exactly because InterDigital would have at any case a right to choose to offer a license covering only cellular SCPs, which has been already found to be FRAND, and therefore it could deny granting this license that would be broader and had a broader scope. The court was not convinced of that argument, however, either, because it said even if you would have this right to choose, which was left open here, making a front determination for a license that would cover all patents has a utility, very practically, because InterDigital might find the terms attractive and might decide then to offer a license on these court-determined terms to Lenovo. But on a more negative note, it could be that the court findings might be relevant for allowing Lenovo at some later point to raise damage claims against InterDigital or even competition law claims against InterDigital. So even if this would not maybe be relevant for the actual terms of the agreement that InterDigital should give to Lenovo, it could have an impact or an effect beyond that and allow Lenovo to maybe assert damage claims or claim at some point that InterDigital, by acting like this, acted in an anti-competitive way. So having said that, the court found that it has jurisdiction. This claim that Lenovo brought has sufficient prospects of success, and therefore it should go to trial and confirm its jurisdiction. Now, as we said already, it might not be the case that the court is going to come so far here to actually do a front determination which would cover all patents of InterDigital, because it seems that there has been a settlement in the meantime. But I think this this reasoning of the court here and the fact that it did not exclude that potentially a license that would go beyond the cellular SEPs could be front, and a patent owner that does not provide such a license could eventually be discriminating the implementer, is something to keep in mind and to consider when it comes especially to this one question of how broad a front license should be at the end of the day.